welcome to our 47th episode of the Constitution of American Life with us, the Friends of Publius. We are now heading towards, I think, our 14th month of this program, beginning a year ago last January. And so this is, like I said, our 47th episode. This is our 8th episode addressing the topics developed for the students in the national finals for the We the People, the Citizen, and the Constitution program. And I believe we've been able to maintain our enthusiasm and our enjoyment with each other in discussing these topics. I personally have spent over 40 years studying history and our Constitution, and I find that the current situation that Americans and the world find themselves in has become the most challenging for me in regards to understanding the principles of self-government and that which makes America, America. Tonight, we're going to be addressing the concept and principle of rule of law by addressing a quote by John Adams. I might suggest to those watching tonight's program that you might want to view our last session on executive privilege, because we do have a lot of discussion on the rule of law vis-a-vis the executive branch, and it might help you as well. In regards to this principle, over time, I have come to see the rule of law as possibly the squishiest of all constitutional concepts. Squishy is, of course, one of our favorite words, and this is, to me, the squishiest of all constitutional concepts. The rule of law is foundational to a just society. At its core, it addresses judicial independence, access to the justice system, and other basic human and economic rights that depend on a fair system of laws, enforcement, and a government that is accountable to its citizens. It ensures that government is less subject to corrupting influences and more devoted to providing peace, public safety, and security. When the rule of law breaks down, government leaders operate for their own economic benefit or to enhance their power, and governmental decisions are made behind closed doors without any public accountability. Without trust in the rule of law, a significant portion of the population will believe that the justice system is stacked against them, favoring the powerful and the connected. And I do believe that is the situation that not only we, but a number of countries are currently in. I have come to the conclusion that the principle of rule of law is at the core of what we call American exceptionalism, is one of the greater myths that we teach ourselves in order to feel special. Now, understand, I could be wrong, as I usually am. There is no doubt that we have some success stories in which rule of law has prevailed as principal idealists like myself hoped they would. US versus Nixon, Clinton versus Jones are great examples of holding the executive branch accountable to the rule of law. In a more local sense, the George Floyd murder case and holding the police accountable for enforcing the law and upholding justice. But we have as many, if not more, examples, in my opinion, of America and Americans falling short of the standard established under the rule of law. According to the Cardozo Law Review, there has never been the rule of law in the United States, at least for not all Americans. Just in this last week, the Supreme Court of the United States has delivered two opinions, US versus Husan and FBI versus Fizaga, that use the state secrets doctrine to clearly deny justice to persons in this country. Clearly deny. All right. And in fact, in the dissents, in one of the dissents, and I believe it is in Husan, that dealt with torture, Justice Gorsuch dissented and said, how could it be a state secret when everybody already knows all the information? Yet the Supreme Court upheld and denied the evidence being used in that case. Also, I would point and direct a lot of you, if you haven't seen it, it is an HBO special on the Adnan Syed case. It comes out of Maryland. He is a high school student who was convicted of murder, and 22 years later, he still sits in prison on a technicality, even though the overwhelming body of evidence shows that he is not guilty and is innocent, yet he still sits in prison because of a technicality. And I find that to be rather disturbing. So I suggest that that might be a great documentary to watch. So I guess the key question that we have to deal with is just how cherished is this principle, rule of law, in America's political, social, and economic culture. How does one even assess this? How do we assess whether or not it is part of our way of life? It is part of the American belief system. Does the fact that we have fallen short numerous times indicate a failure to live up to this principle, or am I just too naive or idealistic? So let's turn to the smart guys and to the ones who know a lot about this, and that is the FOPs, professors. The quote that we have to deal with from John Adams is very brief. He wrote, "Good government is an empire of laws." And so how I'd like to start out is to have each of you, if you have any thoughts, insights on all parts of the question that students have to deal with, or you have any thoughts about my insights on the rule of law. So Professor Kavanaugh, anything about the question in general you have for our students or teachers and audience?
Are you asking me in general, David, about the concept then, or?
Well, again, just looking at the totality of the question, if you had any general comments there, or if you had any responses to my view of the concept of rule of law there. But kids are being asked to, it will get more into how are these laws embedded in our Constitution, our founding documents, what challenges have to the rule of law have we experienced, and then in what ways, if any, has the rule of law been important to the preservation of a free society. So as we've generally started out our sessions, is just any recommendations you have, what I call it. Do you think there's any minefields?
I don't know that there's any minefields. I think that you made a great point in the opening, David, when we're talking about executive power as a rule of law. Everything we've talked about really goes back to one of these foundational principles, because you have a constitution, you have four corners of the Constitution, a la Dean Smith for college basketball. So are the powers of the government, where do you find those within the confines of the four corners? And so students and people always have to ask themselves, when the government does something, where do they find the power? And if you can't point to it, then are we in violation of rule of law? I think that's something for students to think about.
Professor Williams, anything general comments that you'd like to make before we get into some detail?
Yeah, and I'm just going to mention these, and we can get into the detail of them later. But I think, this is, like you said, Dave, this is such a big concept. I think there are some minefields here. I think students need to think about exactly how they want to define the concept and then move forward. So I'll just throw some ideas out. Maybe we'll get into them later, maybe not. But I think, students could think about the different elements of rule of law. I think you mentioned two of them: independent judiciary, access. I think there are some other ones, accountability. I think there are other elements. And as we're evaluating American history and evaluating embeddedness, we might look at those different elements and ask which one of these elements shows up at which kind of time period. I think there's a distinction between what some scholars call formal conceptions of rule of law and procedural conceptions of rule of law. And I think maybe we'll talk about that during this session. I think those are very different ways to get your head around it. And then finally, I really think that a historical view here, and I'm going to go further back than the 1770s. I'm going to go back to, even before the Magna Carta, to get at why Magna Carta was important. There's an inherent tension, I think, in this notion of popular sovereignty, what we might call democracy today, and the sovereignty of law, right? The rule of law and I think democracy are in tension. And I've come across more than one scholar who has said that, a liberal democracy cannot exist without rule of law, yet rule of law can exist without democracy, right? So we can talk about South Africa, we can talk about most of American history. Maybe that's what Chris is referring to of rule by law. But I think that there are these different tensions and different ways to break up this big concept. And I don't think students can cover it all in a 4-minute statement. So they're going to have to decide what they're going to do and then be ready for judges like the four of us to come at them with all these different ways of reconceptualizing it.
Professor Moore?
Yeah, I'm glad Mike referenced, I think some scholars call it thick and thin definitions of rule of law. I think this is a landmine question, frankly, and there's two potential landmines. Number one, this question is in Unit 1, which means, in my estimation, it should be a discussion about philosophical theory. The landmine I perceive is students looking at this question and getting really super legal. Now there's a place for that, but I think ultimately the question is, be careful that this question is in Unit 1. And I think the very things that Mike has referenced about these different traditions of rule of law, I would really urge students to think about these theories of rule of law before rushing to, the Google search of court cases. That would be my first recommendation. Now, again, I realize that I have a set of biases towards history rather than law, but so you can take that with a grain of salt. And the other landmine is if you get lawyers judging you in Unit 1, everybody ought to hope and pray there's a political scientist or a political philosopher or a historian on the panel. Because if you get a panel of lawyers, they may not be as attuned to these philosophical traditions as you might be as a student panel. So I think there's a landmine in who's hearing your presentation, especially if you frame your discussion around these philosophical traditions.
So, well, Mike, I think that's one of the first, pats on the back. He rates you higher than a lawyer. Political scientists in his hierarchy are a step above lawyers.
Oh, I mean, political scientists will know automatically what Mike's talking about by this.
It's just for 1 out of the 6 units, man.
Oh, I mean, they'll know the thick and the thin, the formalistic, the substantive. They'll know those. They'll know those traditions.
Yeah, but I would add, Tim. I think if students are if they have their Hobbesian understanding of law, right? I think if someone wants to bring that to January 6th or to Watergate, students can point out those connections. Well, Nixon's just given us a Hobbesian nature of law, like whatever the sovereign does.
Right.
Okay, right? And that's what Trump's kind of saying too. So I think you're right, though. They need to be aware of that, but they could still make the connections.
Sure.
So, Chris, we're going to start off with you because as I was preparing for this, I quickly went back to our last session because Professor Moore had said something I considered rather profound and provocative, and I've been thinking about it since, and I think it obviously fits into our discussion here. And what he said last week is that the rule of law is not static, that it is evolutionary. And since, you're one of the smartest guys I know, when you heard that, and as you've had hopefully some time to think about it, can you explain your understanding of Mr. Moore's insight there of evolutionary versus static rule of law?
Well, when is Professor Moore not? We're always leaning in. I feel like I should be taking notes every time he's talking. So I don't know that I would agree with him that it's. I don't think, if you think about the philosophy, and Tim made the point earlier about this is in Unit 1, so students make sure you're thinking about this from a philosophical standpoint. I think that's a fantastic insight there. Another fantastic insight from Professor Moore, but I don't know. I think the idea, the concept is static. I think, when you look it up in a textbook, or when you look it up, the ideas of 4 or 5 points of the rule of law that we were just mentioning some earlier, I think those are somewhat static. I think it's in its application that we see, and I'm not sure if the evolutionary is the word I would use. I think it's a very subjective thing. And I think it's, I've railed on this on numerous occasions about rule of law. And I just think it's, honestly, I think we talk to students and we try and teach our students that this is one of the bedrocks. Yeah, so you're right, David, and what you said about American exceptionalism. This is an example of American exceptionalism, but I don't know that it's evolutionary. because the concept is either it's legal or it's illegal, and we have courts to determine that. No, go ahead, Tim.
No, well, no, go ahead. No, go ahead.
Well, I mean, honestly, it is. But then we have to. So, are you saying that we have degrees of legality? Is that? I mean, in this evolutionary process, or simply it's evolving because now more people actually have access, and more people now are covered?
All I was, and maybe the word evolutionary wasn't the right word, but I think I'm going to stick with it for right now anyway. It's my understanding that there's this English version of it, there's a German version of it, and then there's the French version of it. And the English version is their definition of rule of law and how it actually works out is this relationship between common law and parliament. There's a dynamism between those things, and that equals rule of law. The German idea is much more stiff and rigid in their definitions of rule of law. It's very formalized. It's very, and it's actually, there's a lot of moral content in German definitions of rule of law. I think political scientists, correct me if I'm wrong, Mike, would say it's very normative, prescriptive on what's values and morals. Whereas in the English system, it's much more give and take, much squishy, to use that highly technical word. And then there's the French version, which I don't really fully understand, but I know there's a tremendous distrust in the French version. There's a distrust of the courts as being the source of the rule of law. So when I said last week, maybe the better word would be there's great variations in how it's defined. Now for me, when I look at the American usages of that concept, we've introduced two other philosophical ideas in the definition of rule of law. One is rights, which the English and the German don't pay much attention to at all. But when we introduce rights and democracy, that really complicates rule of law and makes it very, very difficult. And it's like nailing Jello on a wall in some ways. So evolutionary, maybe not the right word, but I would say there's definite variations, and the Americans have added a new set of things into how people can think about rule of law.
Mike, before I know you want to say, I just need a clarification, Tim. I want to make sure that I have a grasp of what you're saying. Are you saying that, are we some kind of composite of those influences? Or are we just another variation of those influences?
I don't know, but I do when I hear Chris, when Chris made the comment that one of your comments seemed to infer or imply there's this binary nature that you either have rule of law, and then when it doesn't happen, there is no rule of law. And I think what I kind of hear in that is the German mindset that it's all or nothing. It's a zero sum. Yeah. So that so when I think, unless I'm hearing you wrong, Chris, I hear kind of a very rigid formalistic understanding of rule of law.
I guess I'm just dumbing it down to my level. It's either legal or it's illegal.
Yes, that would be very German.
So, go ahead, Mike.
Yeah. Go and answer him. I can hold on.
No, I do. I mean, I think it's. I guess my frustration is we teach this, right? We try and teach this.
Yeah.
And we try to hold ourselves up, and I don't know how many times students of mine have used the law is king quote, right? And I say when the government is, I think of Henry David Thoreau and civil disobedience. I say break the law when the law is unjust, that kind of thing. And Dr. King as well. And I just think, you guys know what I think. I think we just talk a good game. Well, that's it.
Yeah. I completely agree with that. I tend to agree with Tim that I do like the word evolutionary. I'm not sure if I think there are differences between Germanic, French, and English traditions, but to me, that's not what's important. So to me, it's like going back to Aristotle and Plato, my understanding is that they wanted to find a ruler who would make laws that were moral for the good of the community, and they were restraining popular sovereignty. So that's like one conception. You get to the Middle Ages and you have kings taking oaths saying that they are underneath another higher authority, whether that be a pope or a religious authority. And to me, the break is with the Enlightenment. I mean, there our conception about the collective changes to one of individualisms, and then law is meant to protect individual rights. And the liberal system is one, it seems to me, where there's normative plurality, where the state, the rules are supposed to be neutral to everyone's conception of the good, and that we allow that to operate within a framework of laws, which is very, very different from where we started in Athens, where we wanted to find this Platonic leader who would tell us what the good was and we all live by it. So to me, what was legal in Athens in the 5th century is very different than what would be legal today because of this change.
Let me ask Chris, I know you well enough to know that, I would assume most of us, and maybe all of us in the circle here today, don't see rights as absolute. There's always, and we can fight about how much rights you have once you enter into a social contract. But I do, and I don't think rights are absolute either. There's no such thing as an absolute right. So I guess for me, why I like to make them squishy is if rights are not absolute, why should a principle of rule of law be absolute in a binary sense? You either have it or you don't.
Right.
So I kind of see rights theory involved because there's not an absolute right. I don't think that there is an absolute definition of rule of law.
Well, they're not.
Now
They're not,
that's an arguable point, but that's my analogy.
No,
these are not the guidelines of law. They're the rules of law. And I'm with Chris on this. There's a law. The law is written. All right. Yeah, we've got some obvious ambiguity, especially in our written Constitution. All right. But there is a staticism there, a static element to that, because if there is not, then it's all subject to the political process and the whims and passions of the people. And therefore, a rule is not a rule.
I was with you until you said the whims of the people, because I think the British system would say, no, we can still have this rattle and hum between institutions and not have to pay tremendous amounts of attention to the people. That's an American thing when we add the democratic principle.
So I agree with you, Tim, that no right is absolute. We put limits on every right that we enjoy because to protect the common good, a
Right.
very unit one concept, some low hanging fruit for students right there. But I think there's a difference when we're talking about powers of government versus rights of individuals, because if you're going to provide this squishy notion to the powers of government, that's when I start to get nervous, right? I start to get a little apoplectic, to bring in another one of our favorite words.
So Chris, then would you say, some of the actions by President Lincoln at the beginning of the Civil War were clearly not rule-based. So would you just admit that what he did was against the rule of law? But
Yes.
then you might still argue as a citizen, he should be able to do it.
Well, no, I would agree. What Lincoln did was a violation of law. However, using the idea of John Locke's concept of retroactive authorization or ratification, and part of the reason was Congress was not in session when he took a lot of this action, suspending habeas, calling forth for volunteers, ordering the blockade of southern ports, which of course lead to the prize cases. But he does go to Congress and said, what are you shaking your head about?
Because you just were saying it's binary. Now you're making up all these exceptions.
Let me finish. I'm agreeing that he violated the law. I'm not saying he didn't, right? But I'm also saying that he went to Congress and said, yes, I did this. now you guys make this right.
That strikes me
And-
as very British, though, that there's a
Well,
rattle
but then,
hum
and then
between
when
institutions.
when he runs for re-election in 1864, right, he says, I did these things. And if the people, and he doesn't shy away from them, he takes ownership of it. I'm not excusing them, but he's telling people, if you don't like what I did, do not vote for me.
Right. And one of these sub principles of rule of law, Mike, that you agreed with is accountability. And I think Chris and I would both say accountability isn't an immediate thing. I think there's a reasonable framework for accountability. And in regards to Lincoln, clearly he violated the rules. But Chris is absolutely right that when Congress gets back into session, he pretty much does a mea culpa and say, okay, here's what I did. You guys are back. Either affirm or not affirm, right? And they affirm what he did. And to me, that's the rule of law, all right? Especially given the nature of our structure of government and the fact that Congress was out of session and he was facing exigent circumstances. What bothers me is go ahead, Tim.
Well, I think what's notable to me, and I'm going to defer to Chris because he's much more knowledgeable about Lincoln. But what's striking to me is the dialogue between Lincoln and Congress is really a dialogue about power. I don't think there was much discussion about rights in that dialogue, which takes me back to that seems to be very English to me.
Well, for students watching, this is one of my big pet peeves. As individuals, we have rights, and those rights are to be protected or not at certain times. The government has power. So I don't think the debate between Congress and Lincoln was about, I think it was about power, right? Do I have the power? Maybe it's semantics. Do I have the right to do this? Do I have the power to do this? I think the better way for Lincoln to phrase it, as he did, is, do I have the power to do this? Do I find it within the Constitution?
So same thing with the Emancipation Proclamation. Was that a violation of the rule of law?
No. Because the president has the authority, as we see. Students see the last episode, or wait a minute, it's about the executive, right? Executive privilege, and so with one of those things are executive orders, and presidents have used executive orders for years, right? And the Emancipation Proclamation was just one more executive order that we know the president has the power to do that.
And it's narrowly tailored to executive, war powers. He didn't emancipate every slave. He only emancipated those slaves that were behind enemy lines.
But to use your principle, why wouldn't he have to go to Congress immediately and say, make a constitutional amendment? Like we did with, eventually the 13th Amendment is meant to solidify what the proclamation did. So given what your argument, what's the time period of which you go? Can FDR,
my question,
executive order and intern Japanese Americans and then wait 4 years and be like, my bad, Congress, can you make this right? And then that's still okay?
The Emancipation Proclamation was an executive order. By issuing that, tell me where he stepped outside of his powers of Article 2. Because we've accepted the idea that the president can issue executive orders. So where does Lincoln step outside of his power under Article 2 by issuing that executive order?
Confiscation of property of American citizens.
They're not American citizens.
Well, he said that they were at the beginning of the war because he refused to acknowledge that they were a separate country. So that complicates it, right?
Well, therein lies, now you said to avoid the legality here. We're going to stay on Lincoln, right? And students, if you go to the prize cases, therein lies getting the camel through the eye of the needle, because you don't want to admit that these states are in rebellion because your argument is they never left. So how can you confiscate ships, right? And the court gets that camel right through that eye.
I'm not holding him up as a bastion of consistency. All I'm proposing is it's a nightmare when you try to apply it stiff and rigidly. That's all I'm saying.
Well, my point was addressing Mike and the idea that I don't think that Lincoln stepped outside of his powers. I don't think he stepped outside of the Constitution in issuing the Emancipation Proclamation, because let's face it, we all know this. It didn't free a single slave. It did not free a single person. It was a political document designed to get the abolitionists off his back and keep England out of the war. And enslaved people will not be freed until the Northern armies actually they take control of the territory.
But if a president can order like to look at all of our cell phone records, it doesn't matter whether it's successful or not. Like it's a question of does he have the power or she have the power to do it, and whether that's inside the rule of law. I'm not as I don't know how I feel about executive orders and whether, I mean, executive orders to me are like the prerogative powers of kings, which it's not as simple as like, yeah, that's Article 2 power. It's just, I think there's a bigger debate there.
I'm not disagreeing with that. I think
and who knew how long we could go just on Mr. Moore's comment from last week. So no, I kind of expected that. Professor Moore, do you agree with the statement in the question that this principle is embedded in our founding documents? And I just have one need for clarification. Obviously, within the Constitution, I think the students can find probably numerous references. I am wondering, however, about the Declaration. Where is it in that part of when government fails to protect the rights of the citizens have the right to alter and abolish? Is that where we're seeing the rule of law, or is it in a list of grievances?
Well, sure. I mean, the colonials argued that they had followed rule of law. They were good Brits. They petitioned. There was national petitions coming from the Continental Congress. There were state petitions, colonial legislature. I'm speeding up the revolution there. There were colonial legislatures that had petitioned. There's also violation of rule of law, and Brits are great at that, by the use of violence and going after their governors and not. So I'd say that the colonials say that they were following the rule of law, and that fits in that long train of abuses. To your point about the Declaration, they had followed rule of law. Even the Tea Party, they waited till the 29th day before they went down to the docks and tossed the tea. Even Shays was making the argument we'd petitioned our legislature over and over and over again for tax relief. I think there is this argument that even in the Revolutionary era, there's this notion of procedures within the rule, and that equals the rule of law. And in a culture, in a British sense, it's a cultural thing as much as it is a legal thing.
So is there, this is to any of you, is there, beyond the Constitution and Declaration, is there any other, founding documents that you might guide students to see this principle embedded?
There's a great, I have to get the Massachusetts Constitution of 1780 in here. There's a great statement in that 80 document. Let's see if I can pull it up here. No man nor corporation or association of men have any other title to obtain advantages or privileges distinct from those of the community than what arises from the consideration of services rendered to the public, and this title being in nature neither hereditary nor transmissible to children nor descendants, relations of blood. The idea of a man born a magistrate, lawgiver, or judge is absurd and unnatural. So I think, and there are other state constitutions that have similar statements like that, but I would recommend for the students' consideration that Massachusetts Constitution of 1780.
So, Mike, over the years, I have constantly reminded students when I taught that law is only as good as the ability and willingness to enforce the law. And I guess one of my struggles with this notion of rule of law is that our Constitution, in my opinion, seems to lack areas of enforcement and accountability when it comes to the rule of law. Do you agree with me on that, or am I off base?
Well, I mean, let me make sure I understand where you're going with this question. We have this concept of rule of law, but we depend upon human beings to enforce it, and that's where
we depend upon a political process,
right,
to enforce it. And I do believe there might be some other mechanisms. I mean, I think Tim mentioned before maybe the primary institutional enforcement was going to be in the courts. And I think that we have found in our history that the courts have been again, overly influenced by the political process itself, and the political culture that each court finds itself in. And just one little example, we have not had a single president in the United States ever found guilty in an impeachment process. We've had 46, and we all know, quite a bit about a lot of presidents, not all of them, but a lot of presidents. And we well know, all right, that a number of these presidents, all right, went outside the bounds of law. Yet there really is no effective, all right, way to enforce it except a political process, of which I think it's failed. I mean, again, President Johnson, the first one in the 19th century, clearly violated the law. All right. Now, yeah, maybe it was a setup by the Republican Congress to do so, but he clearly violated the law. He's found not guilty. Yeah, I guess we can claim Nixon might have been found guilty. We will never know there. So that's my one example. 46 presidents, of which we know a number of, some elements of corruption outside the box in law, but not one of them held accountable, for that. That's kind of my piece of evidence.
Yeah, no, and I see that. I would argue that the Constitution provides those mechanisms, and what you're upset about is the way in which the mechanisms have been used to get to the result that you think is just. So, I mean, a president takes an oath that the laws will be faithfully executed. To me, that's an area where we see the president and the executive branch is in charge of that. To the extent that judicial review, as we've discussed in numerous sessions, is implied in Article 3, and that then Marshall kind of lays out that we have the power to say what the law is. If equality before the law is something that we think is part of our understanding of rule of law, yeah, the courts are to play that kind of role, right? Now, I think what you're getting at is, as Madison pointed out in the Federalist Papers, right, that we're not angels, and we have men and women making these decisions, and the law itself is indeterminate. I mean, part of the frustration is that so many actors can make arguments and counter arguments within this spectrum that we call the law, which means that sometimes we don't get to those results that we might know in our brain or our hearts that are the right ones. I don't think that's a lack of having something in the Constitution. And then my final statement would be, for the centuries of human history where we haven't had that check of popular sovereignty, I don't think it's like a throwaway to be like, oh, I guess we could just not elect someone if we really don't think, that they should have been impeached, and then we just don't elect them. That's, who knows the cause and effect here, but that's what happened in 2020, right? We had 2 impeachment attempts that failed, and the person who was impeached didn't get elected. I don't think we can just like throw that away. That's a powerful check for the rule of law. It's citizens using their power not only at the ballot box, but in civil society.
I don't disagree, Mike, but I got to push back a little bit. So you're telling me our safety net is the people. So when the institutions of government fail to perhaps use their powers to hold other branches in check, our safety net is the people.
It's one of them.
Sort of. There are so many. We've separated government. We've separated powers, and so if you give some credence to this, the Jeffersonian view that all 3 of those branches have a role in interpreting, we've set up a nightmare. 3 institutions, 50 different states. And then there's the people. So I think to say it again, Chris, I can't help but hear a binary nature to your question. I think the people, there is an argument. I mean, Larry Kramer made it in that great book 10, 15 years ago, The People Themselves, that the people do have this check he almost inferred an intuitive sense of justice. So again, I hesitate about the zero sum nature of your perspective.
Well, I mean, is it justice though for people to be able to violate the law and not be held accountable? And the fact that the only way they don't get held accountable is because they don't get reelected.
Well, I think Mike can help me here. I think if you're into the formalistic, thin view of rule of law, the answer to your question is, yeah, you can have that.
Well, let me share with you Madison from Federalist 57, because I think this is interesting. That America's by definition, quote, can make no law which will not have its full operation on themselves and their friends, as well as the great mass of society. Is that what happens now?
I have no idea.
Well, I mean, I'll use a current example. Crystal Mason. You guys know who Crystal Mason is? Crystal Mason, who is a woman who voted in Texas using a provisional ballot because she was on parole for federal charges of fraud. And she cast a provisional ballot because that's what the poll worker told her to do. And she thought that she was within her right to do this. She didn't know that she was breaking the law, right? Technically breaking the law, even though her ballot was a provisional, it was never counted. They're trying to put her back in prison for 5 years for doing something that clearly was was it a violation? Yes, but was it a misstep? Here's where we could get into the squishy nature of the enforcement. Sure. But then you look to see where recently Mark Meadows, and it's just been reported that he has actually filled out a form, perhaps not being truthful about his place of residence. Do you think Mark Meadows is going to face 5 years in jail for forging or maybe not being truthful on claiming to own a residence? I don't think he will.
I don't think he will, but I also would hope that if this woman goes to trial, there'd be jury nullification. There's people
right now they've actually had to review the case. They've actually had to.
Wouldn't a jury and nullification be a great example of populist rule of law in action? Could be.
Yeah, but okay.
Yeah. Well, I want to say, because somebody I can't remember which one of you went to Federalist 51 and said hey, we're not angels. Well,
Michael. That was Michael.
Right, but within that same Federalist 51, and here is my frustration. All right, here is their answer to that, Mike. Yeah, we're not angels. All right. In framing a government which is to be administered by men over men, the great difficulty lies in this. You must first enable the government to control the governed, and in the next place, oblige it to control itself. A dependence on the people is in no doubt the primary control, but experience has taught mankind the necessity of auxiliary precautions. They failed miserably on the auxiliary precautions. Okay. They have no, in my opinion, no effective, system of government to control itself, because it all depends upon the political process and self-interest. And over time, I might give us more credit early on in the Republic, all right? But especially since World War II, all right? And let's not forget, we can't have rule of law if 15% of the population, African Americans, rule of law never applies to them until possibly, as you have said for months, Mike, until 1965. And so it's poetry, makes me feel good, but in the end, there's a total breakdown in their structure.
Let me offer, look, I am as frustrated with the application of rule of law throughout our history as you are. I am also super pessimistic about how fragile this system is. It's just, when I look comparatively, right, and to think what other systems are able to sort of hold, we have been able to hold a lot the last 250 years. And I think even in the most recent episode, right? I mean, I think it was Chris that pointed out the excellent Gelman article in the Atlantic Monthly. And that article, I think, speaks to Tim's point. Before January 6th, there were what was a month and a half of concerted legal administrative efforts by the Trump administration to find the votes, to find the process through the legal mechanism. And at every instance, in some way, he couldn't get it done. He failed. Now, Gelman argues, look out for 2024 because that it's gonna be a different landscape. But I think to Tim's point about the way the system is created, there are all these points in the system where you have individuals there who have the discretion to make decisions that can keep the rule of law. I don't know, alive is the wrong word, but you know what I'm trying to say. So it's not as bad off as you're making it, but is it pretty scary and is our history pretty bad? I would agree.
And I think to Chris's point, I mean, the way I look at it, the American experiment has interjected a fantastic set of principles, highly contentious and debatable, but the insertion of rights into the question of rule of law is a great American evolutionary step. I don't know that it's solved all of our problems because we still debate about whether, we should have, is it fair to put 120,000 people in relocation camps? But that's the beauty of the American addition to this notion of rule of law. When they interject rights as a higher principle, animating rule of law, I mean, that's a remarkable thing, but it's not without its problems. That's all my point is.
So Chris, I know in my opening, I gave some examples. I'm wondering if you could build on that do you have an example, even though like me, you're more of a cynic about this notion of rule of law, and America has been a great example of this, but do you have an example of when rule of law played out as people like I envision, as principled idealists that we hoped it would? And on the flip side, do you have an example of what you would call an egregious example of the rule of law failing to live up to its promise?
Well, I think you mentioned U.S. v. Nixon. I think is a good one. This is I was just looking this up because I love this quote, and this is from Ex parte Milligan during the Civil War. Now, granted, Lincoln is dead. So maybe it's easier for Justice Davis to write this because Lincoln loses in this case with Lambton Milligan. And this is Justice Davis. By the way, Justice Davis was put on the court by Lincoln, and Justice Davis was Lincoln's campaign manager. So when you look at the court in U.S. v. Nixon, and you look at the number of justices that Nixon put on, you had one abstention in that vote against when he got struck down. But this is Justice Davis. Wicked men, ambitious of power, with hatred of liberty and contempt of law, may fill the place once occupied by Washington and Lincoln. And if this right is conceded, and the calamities of war again befall us, the dangers to human liberty are frightful to contemplate. And he's talking about the suspension of habeas corpus and the idea of Lincoln being able to do this. And so here's Lincoln getting slapped down by the court, even though, again, Lincoln had passed by this point because he had been assassinated. But this is the court, the opinion written by his former campaign manager. So I think that's a very, very historical one. I just love that passage about wicked men ambitious of power. I think we might have seen that, in the last 100 some years. In terms of the place when it hasn't worked, oh my gosh. The Crystal Mason thing just really frosts my granola for students to look up what she has gone through. And she was just there was no maliciousness on her part. Here's a woman who had served her time. She was out. She thought she was doing the right thing. She wasn't sure. The poll worker says, go ahead and fill out a provisional ballot. And now she's facing 5 more years in jail.
And I'm sorry, Chris, where is this located?
Texas.
Okay. So if this was in California, I think it'd be pursued. I'm just wondering, and this is part of my problem with rule of law, is it's so contextual to the political process, especially as we get to the state and local level of what community you live in.
Right.
There.
Yeah,
I'm just wondering that. Yeah.
Well, I think that's our favorite F word coming into play there as well. Federalism, and at the state level, it's going to be different. And you're absolutely right on that, David, in that assessment. One other example I would say that really just make sure I'm not being one side versus the other. when President Obama's drone program, right? The idea that I've looked in I've read the Constitution this one time, and I was trying to find it and I couldn't find it, where the president has the power to be judge, jury, and executioner of people by getting on the kill list, which I didn't find that in there. But evidently, it's covered under the authorization for the use of military force. Somehow it's okay, and we don't get a lot of pushback. The one guy that pushed back on that got shouted down, Dennis Kucinich from Ohio.
Well, and I'm just curious, is the authorization of military force synonymous with a declaration of war?
No.
And again, we get back to, I guess, the squishiness of the rule of law here. Either of you, other professors here, have any examples you want to throw out on where, it worked? And I think, Mike, your point, and I'm going to grant that, in a comparative sense, although I don't know if I'd go as far, but in a comparative sense, we're still defined as a liberal democracy, a constitutional republic, although we keep falling. In my research, there's an organization called the World Justice Project, and a report was recently released by them, and America's ranking as far as when it comes to the rule of law is falling internationally. Now, a lot of countries are their total number, and I suggest you go to the World Justice Project to look at how they came up with the number there. So I would agree with you that a comparative point of view, we're probably doing better there. But it's still a struggle for me. But do any of you have another example of, hey, this has really worked, or another egregious example of where we've fallen short? Tim or Mike?
I'll let Mike handle that. I don't have anything to add because I think, yeah.
I was actually wanted to ask you and Chris, Dave, about the Nixon example, because I'm wondering if a part of the rule of law is this idea of that hold leaders accountable. Does the pardon of Nixon, how does that feature? I mean, the Supreme Court case is one thing, but how that whole thing ended, doesn't he kind of get off scotch-free? And isn't that through a power that usually kings are granted? So how does we can hold up Nixon up as the good example, but then how does the actual, how it turns out, align?
Well, I separate the case and, not allowing the president to use privilege, all right, to hide evidence in a crime. To me, that the case is an example of how the rule of law should work out. The pardon power, in my opinion, is an example of where we fail. That, and in fact, there are some talk about if there's some way we can kind of address the pardon power and put some, more barriers on it there. So I see those as two different things, and I would agree with you. U.S. versus Nixon, yay. Boom, he resigns and he can be criminally prosecuted, yet he's pardoned. And to me, that's part of the whole problem. I find our government, especially today, to be a government of elites. All these people hang around in the same social circles, hang around with each other, and in the end, it's scratch my back, I'll scratch yours. In the end, they're not going to hold it. Congress is not going to hold the president, accountable, and the president's not going to hold Congress accountable. Why? Because they all run in the same circles. We're not a government of the people, by the people, for the people. We're a government of the elites, and as long as they can keep the people economically happy, the people don't really, and that's kind of a lead into a question I have for Tim. I don't know if the people are doing their job there. So I see them as two different things, Mike. Does that make sense?
Yep, completely.
Well, and the Anti-Federalists were suspicious of that pardon power for that very reason. That's all through the Anti-Federalist literature, that the executive power is antithetical to this principle of rule of law. So,
yeah. So that leads to the question, Tim. I mean, we know, my opinion is about the institutions. That rule of law was going to be theoretically upheld through representation and institutional accountability, as you talked about, in these three separate branches. And then as Chris brought in, federalism, these things are all going to, to hold the system accountable to the rule of law. I'm wondering, what responsibilities did the framers envision for the citizen, the average citizen? What role did they think the average citizen would play in regards to the rule of law? Was it just going to be elections?
I think primarily, yeah. I mean, let's not fool ourselves. The founders are elites, and they had a lot of expectation of deference. I mean, they studied Latin, so the whole revolutionary ethos was, yeah, we're in favor of a revolution, but we're not in favor of populists being in charge of anything after the revolution. So there's minimal commitment to Joe Lunchbucket being involved in this. And I think, you read a piece of Fed 51, which I think, Madison goes through all of the auxiliary precautions and the branches and whatnot. But ultimately, I think he throws the Democratic sop out there rhetorically, a reliance on the people. I have my suspicions about the commitment to the bottom up role in rule of law with our founders.
Anyone else on that notion of the people? Because I guess my frustration, and Tim, you're absolutely right, and we've talked about that, the original framing, the early republic, and we've pounded on it. The distrust of the what you call populism, or the average people, that's, to me, embedded in the Constitution.
Let's not forget the jury box. I mean, there's an element of commitment to popular rule of law in jury boxes, in nullification. So I think, and it doesn't happen much, but it's there. So I think there is some commitment to people's role in the jury box.
I think more generally, I go back to this idea of the idea of popular sovereignty is an important check. What's troubling to me is that it's the data we have shows that more and more citizens are cynical, apathetic, and they're kind of just like your point, David. This is an elite game of which my participation doesn't matter. So let me just focus on getting enough stuff where I feel happy, right? And as long as I can have that stuff, I'm going to keep going on. And, when we think about rule of law, as I think David, you used the term respect earlier, to me, it's a cultural notion of rule of law is this idea of voluntary compliance with the rules. And I think we have to ask questions if people don't trust that there is a rule of law, well, why is that? And then what are the consequences in terms of then the elites continuing to do what they do? Because I think we well know that elites are going to keep accumulating power. And if that's not happening, if those checks are not happening at the horizontal level, like we envisioned, and now it's not happening at the vertical level because citizens aren't participating, it's a downward spiral that is, it's not an on or off switch. I really do think democracy is a dimmer and it can dim and it can then, I don't think it's on or off, but I think it's dimming rather quickly. And I think it's something that we should all be worried about.
Well, and I agree, and then wholeheartedly there, and that's why I think it's one of the fundamental reasons why we are seeing study after study, poll after poll, seeing rising distrust, not just in civic and governmental institutions, but even in non-governmental institutions. There, to my knowledge, there's only one institution that still maintains an over 50% kind of approval level, and I wonder about this, but it is the United States military. But every other institution, you start talking to Americans, schools, no, they just don't have a trust in schools, hospitals. I mean, look, the battering at the healthcare system, and I'm not talking about the millionaire doctors and the pharmaceuticals. I'm talking about the frontline people, who are, getting, people are getting in their face and they're angry at them. Churches, themselves do not have above 50% approval rating there, or a trustworthy on the trustworthy index. And so in the last analysis, I think, and that probably feeds my frustration, Mike, is to me, that's the, that's the urgency here. And I guess I'll close to all of you, but I'll start with you, Mike, and that is, what do you think we can do about it at this point? If in fact you're right, that it's dimming, all right, it's not an on-off switch, it's a dimming light there. But at this point in the 21st century, 21st, right? We're in the 21st. I don't even know what century we're in anymore. What do you think we can do about it? And while you're thinking about it, the third part of the question that students have to deal with, I don't even know how to address, because it's like a no duh. And I think we've addressed it in the conversation. In what ways, if any, has the rule of law been important to the preservation of free society? I don't know if you can have a free society without rule of law. That's my short answer there. And so if indeed we've lost faith in the institutions, we've lost faith in the rule of law, how long can we maintain a free society if in fact it is dimming?
Yeah, if I had the answers to those questions, then
you'd be president of the university.
Something like that. I don't, the answer of how long, it's a great answer, and history kind of teaches us that it kind of depends, but these are things that it's not an overnight thing. It's something that's gradual, and I think we're definitely we're in a decline, as you've already mentioned. Now, what we can do about it, I hate to do this. It's going to sound so cliche-ish, but the same author who wrote this great Atlantic piece, Gilman, a year earlier, he wrote a piece on the importance of civic education and the importance of developing civic education so that more Americans understand their rights, understand the conflicts within the Constitution, understand ways to have these conversations in ways that doesn't fuel the polarization. I say that because that's what every educator says, right? You fix it, better education. And I say that knowing how the local sort of conflicts of like, what do you put in a civic education curriculum? And I know the three of you know way more about that than I do. But to me, that would be something that is a possible way to kind of get us out of this.
It's one of the factors that where I look to Yahweh and say, thank you, that I'm no longer in the classroom. I could not teach civic education. All right. I could not teach we the people the way I taught we the people. All right. For decades. I could not do that any longer in many states. All right. Because part of civic education is obviously discussion and debate over some very controversial issues. All right. And as I'd open my U.S. history classes, I'd say history is offensive. Well, now in many states, we're not supposed to offend anybody, and we sure can't get in a debate over LGBTQ issues and things like that. So I'm glad you recognize that. Yes, civic education, but gentlemen, isn't the political culture of the United States such in this moment that that's probably not even possible to do, even if we found silver bullets of how to bring great civic education to every student in America? Chris, Tim?
Yes, it's really difficult, I think, because who gets to define it, right? Who gets to define what is good civic education? And that is clearly in the debate right now, who gets to define history, right?
Well, it's been defined by Margaret Branson, and I think she did a fine job. God rest her soul.
Well, I'm not going to, there's no way I'm going to step on Margaret's toes, and I would never disagree with her. Yes, but in terms of where we are right now, it's very difficult. Going back to your question with Mike earlier, I was thinking of, Tom Mann and Norm Ornstein. I maybe have alluded to this before. They have a book. It's a follow-up. It's called "It's Even Worse Than It Looks." It probably came out about 5, 6, 7 years ago. And one of the things they said that we have politicians that are in a separation of powers government, acting like they're in a parliamentary system. Because, and I've said this before, and this is part of the problem, and I think this speaks to the frustration of the people. And I'll try and connect that dot. But the whole idea is that, you know, instead of having this institutional loyalty, ambition being made to counteract ambition, you have party loyalty now. And then when people see this and they bought into this because of this constant barrage of the echo chambers that people live in, right? These stovepipe mentalities that people have, and they never get outside of their bubble. So when they see an institution actually holding someone accountable, they see it as political in nature and not constitutional in nature. And therein lies part of the problem, I think. Does that make sense?
Tim, yeah, it does. Tim, you get the final word today.
Yeah, I think I've heard the word trust quite a bit in this hour. I can't help but think that this goes back to this idea of social connectedness. I can't help but think that for a revigoration of the rule of law and us having a better batting average, it may come down to us trusting. I don't know what it would take, but something has to happen for a revitalization of trust of institutions and ultimately of each other. So I think the social isolation that we've endured the last couple of years, I also think the crushing individualism that we've experienced in the last 100 years, I think feeds into this notion of a distrust of institutions that we've, for better or worse, turned over. This idea of do we trust? First of all, I don't trust courts to be the arbiters of rule of law any more than I trust the people. I think there are weaknesses in all the branches and all these entities. But I do think that there has to be some kind of revitalization of a communitarian connectedness for rule of law to work. And that's a cultural project more so than a legal project. Mutual understanding of rule of law is a cultural thing, I think, more than a legal thing.
Right. And I think that's a wonderful way to wrap this up in a topic like most topics we deal with that are not simple answers on a multiple choice exam. And you can see that in our discussions here. Next week, Professor Moore kind of gave us a transition when he talked about jury nullification. Next week, we're going to be talking about jury trials there and due process of law. And so again, another easy subject to get our hands around. And so we look forward to that. Until that time, peace, love, yogurt tacos. Bye-bye, bye bonds.